Well, good morning and afternoon to everyone. My name is Ryan Wagisback, Senior Vice President here at NATA. Today we're going to be discussing the current challenges in our workforce as it entails to employment law. So today we're honored to have Alison Squiccimarro of the Law Offices of Paul Lange and Michelle Morgan of Shackelford, Bowen, McKinley, and Norton. Please, questions are encouraged. If you can, please write them in through the webinar system. Allison, let's get started.
Great, thanks so much, Ryan. I'm welcome to have this opportunity to speak to the members today about some of the concerns that they're facing as employers, in particular as aviation employers. As you can see, we've put up on the slides the links for the guidance from the CDC, from OSHA, and from the EEOC. I've provided those links because the information that we're going to provide during this webinar is rapidly changing and has changed over the last months, weeks, days, hours. It's changed dramatically over the last, roughly month to 6 weeks that I've been heavily involved in addressing these issues for our clients. So I can't emphasize enough the importance of referring to those links for guidance. The place we're going to start off today is on best practices for employers who are continuing to be operating. So these are all the employers that are either essential or who have moved to remote. And I'm speaking from somebody who is in Connecticut, where things are fairly well restricted, not quite as restricted as New York. And I recognize that many other places in the country there are definitely not as restricted, and people are continuing to conduct business and actually maintaining their workplace. So first things first, you want to follow the CDC guidance and their recommendations wherever possible. If you have employees that can do their jobs from home, send them home. Let them work from home. We can't emphasize that enough in the current scheme of things. So if you need your employees to be in your workplace, some tips for you to try and manage that in the current environment are: make sure, and you've probably heard many of these over the last several weeks, you want to make sure that you're encouraging hand washing, encouraging social distancing, encourage your sick employees to stay home. If you don't already have a policy for reporting illness, implement one and encourage your employees to communicate with you if they are in fact ill. Encourage them to self-monitor for symptoms and to report those symptoms if they do have symptoms of COVID-19. You want to encourage them to maintain healthy habits. Sit them down, talk to them about the importance of getting plenty of rest, exercise, sunshine, all of those things that we lose sight of in the day-to-day managing the sense of urgency. But those are really important, and you as employers should be talking to your employees about those things. One question that has changed, the answer to has changed, is whether or not you can take an employee's temperature as part of trying to keep your workplace healthy. And when I started this about 6 weeks ago, COVID-19 was not a pandemic, and the guidance on that was generally that would be a medical exam, and you'd have some hurdles to overcome on that. However, in the face of a pandemic, the guidance on that has changed dramatically, and now employers are in fact allowed to take their employees' temperature. It is still considered a medical exam, so you've got to document it and document it for everyone, fever or not fever. Whether an employer chooses to implement taking employees' temperatures is their choice. There are some concerns because you are taking a medical exam. So you want to make sure, that your thermometer, that you're doing it in the least invasive way possible. Forehead scans are probably the best if that you're going to do that. If that is something you're going to do, you have to document it really clear, have a clear policy. 100.4, and you go home. You want to monitor that against the CDC guidance because the CDC at some point may change their recommendations on, what is a fever. But right now, as of when I checked this morning, it was 100.4. You as an employer, if there's any opportunity to increase the ventilation in your workplace, do it. If you can create physical barriers between your employees, you want to do that. Other things to think about on that is if you could limit the amount of people in your workplace. So you as employers can do some things. You can eliminate any non-employee from being present in the workplace to the extent you can. I realize that there are many businesses that's impractical, but if you can close off your workplace to the outside world, that's a good positive step that you should be doing. You should also look at whether or not you can reduce the amount of people in your workplace at any given time so that they can maintain the social distancing. Staggered work shifts, rotating employees are all things that can help you maintain, a healthy workspace. As far as I know that there's many 135 operators, they have concerns about keeping their crew safe. You want to keep that in mind when you're sending them out to places. You want to keep them as safe as they can. You want to the best that you can, you want to avoid those hot spots that are popping up. New York City is the most recent of them, and that's a really difficult one. So those are the things that you can do. You as employers all have an obligation under the Occupational Safety and Health Act to provide your employees with a safe workspace. If you have an employee who expresses concern about their own safety in the face of this pandemic, you've got to listen to them, hear them out, and try and work with them. Try and address their concerns, make them feel as though they're being heard, and work with them. And most importantly, you can't retaliate against them for having voiced a concern about their own health and safety in your workplace as it relates to COVID-19. And by retaliate, you can't, really simple, you can't disparage them, you can't, demote them, you can't terminate them, you really can't take any adverse employment action against them for having voiced a reasonable concern about their own safety in the workplace. So I think I can't emphasize that enough. I've had a lot of employers that have called in the recent days and said, my employees are, demanding these things. They're not being reasonable. How do I manage it? And the best advice I can give is to, sit down, talk to them. If they feel like they've been heard, if they feel like they've been accommodated, if you even meet them halfway, you're making some progress towards mitigating the risk that, you have a problem there and that they effectively become a whistleblower on you. So those are things that you want to be really careful about. The other thing that I just want to touch briefly on is the question of, is COVID-19 exposure, is that a reportable OSHA incident? And that really depends on whether or not you're required to report workplace injuries. Generally, if you know that you're required to report a workplace injury, you may have to report a COVID-19 exposure. So the things that would lead you to making that determination over whether or not you have to report it is, do you have a confirmed case? Is this, has there been a test, or is it just a, presumptive case you need that. It's not going to be reportable unless it's confirmed. It has to be, the exposure has to have occurred in the workplace, and then it has to involve, days away, medical treatment, significant illness. Somebody who contracts COVID-19 is likely to meet that standard. So you want to be careful of that and, make the appropriate report if you're required to. And, I think that's launches perfectly into the next phase of this webinar, which is, Michelle's going to talk to you a little bit about sick leave, family medical leave as that pertains to COVID-19.
Thank you, Allison. Hi, everyone. This is Michelle. Delighted to be here with you guys today. Allison mentioned these things are changing rapidly, so I agree with her 100%. You should be checking out these websites with some level of frequent basis if you don't have somebody that you're reaching out to from a lawyer or a tax advisor who you can ask questions for. The websites are really doing a fairly good job, I think, in a short amount of time trying to push some information out in a user-friendly fashion. So big news on the front of the COVID-19 pandemic in America. The government is aiming to help employers when they enacted the Families First Coronavirus Response Act last week on March 18th. It was due to be effective no later than 15 days after it was passed, which would put that date as no later than April 2nd. There's been some conflicting guidance, but as of last night, the DOL has issued documents on their website that indicate April 1st is the go live date for this act. It's going to apply to companies that have fewer than 500 employees. Covered employers, anybody with fewer than 500 employees, are going to have to pay eligible employees paid leave when they are away from work because of something related to the COVID-19 situation. Think of that as the big title at the top of the bill. There's multiple subparts. For today's purposes, we're only going to address two of them, but they matter. The Emergency Family Medical Leave Expansion Act and the Emergency Paid Leave Sick Act. If you're familiar with family medical leave, this is really just adding another qualifying category of why you can take time off and you'll be paid, whereas you still aren't for other family medical leave acts. The Emergency Paid Sick Leave Act is almost intended to cover probably in effect lots and lots of people if there are diagnoses coming through. So again, it goes into effect April 1st. It's going to expire December 31st as it's written now. So if there's a bucket of leave that is filled by the Emergency Paid Sick Leave Act, and on December 31st, you have employees who never had to take it, never asked to be paid it, it just vanishes. They can't carry it over. You don't have to write them a check for the value of it. This is really to get us through the end of 2020. So with that, if we look at our next slide, this is talking about kind of how people are going to be paid. So I think the most valuable piece on this graphic is probably the floating boat at the bottom, because the way it's all designed is while the employers will have to float this money that they're required to pay, you're going to get it back in concept with tax credits. So eligible employees who are paid the way they're supposed to be paid in accordance with the statute, when you turn around and you have a quarterly tax due, you're going to get a credit. So hypothetically, you owe $20,000 in taxes, you paid $16,000 out of pocket under the Sick Leave Act on that particular payroll tax cycle. You don't actually have to pay $20,000, you're just paying the $4,000 difference. So that's the goal, and it's part of why it's so critical that you do this correctly, because there is certainly an expectation that if you submit your reimbursement request for all practical purposes, this is what I paid, may I please have my tax credit, whether you get that credit or not is going to be dependent upon did you handle things properly. So like many things in employment law and certainly many things in the world of taxation, and I'll caveat, I'm not a tax lawyer, you really have to check all the boxes that need to be checked so that you're not worrying about, am I really going to get my credit? So, and that's pretty evident. Next slide. Do it right, get tax credit. So that's a good thing. You get a dollar for dollar reimbursement for all qualifying wages. So that goes back to the, do I really get my tax credit? Well, which amount of money are you asking for the credit to apply to qualify as appropriately, properly paid under these two acts? And then you're also going to get credits extended to maintain your health care coverage. There's some tax forgiveness on whether you have to pay Social Security taxes or match or pull from what you're sending out to the employee. I would strongly encourage you to give a ring to whoever your tax advisor is, your CPA, your tax lawyer, whoever it is you're using on the front end. They too, I promise you, are keeping up with this so that they can guide their clients on these tax-related issues. Next slide. So there's two, I mentioned that there were two subcomponents to the Families First Coronavirus Act. The first one is this emergency paid sick leave. You see on the screen, there's two columns. One I would refer to as self-care. The one on the right I would refer to as care for others. These are very similar. It's why they're next to each other on this slide. So if you have an employee who is unable to work or telework, this is self-care, because the employee is subject to a quarantine order, because the employee has been advised by a healthcare provider, that's the HCP, a healthcare provider to self-quarantine, or because the employee is experiencing symptoms and they're seeking a medical diagnosis. And what we anticipate and expect they mean by that is you've got an employee who's home with a cough and shortness of breath and a fever, and they may not have been tested yet, but they've been on the phone with their doctor or they've been on telemedicine with their doctor, and they are waiting to get in, whether it's a drive-through or somebody comes to their house to get a diagnosis. So if your employee personally is experiencing one of these things as it applies to them, they are entitled to up to 2 weeks of pay. You would calculate the amount of that pay as their regular rate of pay. So if you have somebody who's hourly at $30 an hour and they usually work 40 hours a week, they get that 30 hours times 40 hours a week for 2 weeks. If you have an employee who's part-time, maybe you've got somebody working for your shop part-time, $20 an hour, they work 12 hours a week, they get 24 hours of total pay. So you may see lots of places that say the Emergency Paid Sick Leave Act gives you 80 hours of paid sick leave. That's true if you, the employee, or your employees are full-time workers. But somebody who's part-time is not going to get 80 hours. That's just a cap. And then people will say, well, how do you calculate that? It's really easy to calculate that for an hourly employee. It's pretty easy to calculate that for a salaried employee. You take their salary and divide it by 2080, which is the standard 40-hour work week across 52 weeks. Those are pretty easy. What do you do if you have a commission component? Maybe you've got somebody who's selling something and they've got a commission component. Look at up to the last 6 months and come up with an average. If the employee's only worked for you for 3 months, just use the 3 months. If they've worked for you for 15 years, you just go back to the 6-month look-back window to come up with their regular rate of pay. And then notably on this self-care trigger, if that's the reason your employee is out, your maximum daily rate you have to pay them is $511, and so for 2 weeks, that's $5,110. If their calculated regular rate per day is $250, you just pay them the $250. So again, you don't have to go up to the $511. You go where the math points you, but if it's higher than $511, you get to cap it off. So then if you look at the right side of the slide, care for others, this is if the employee cannot come in and work and they can't telework because they're caring for an individual subject to one of these quarantine isolation orders, or because they're caring for somebody who's been advised by a healthcare practitioner to self-quarantine. It does not apply to you're waiting in the wings for somebody who might have symptoms or does have symptoms to get a diagnosis. That you can wait for that at work and keep up with that. So it's just limited to the first two of the self-care, which is isolation quarantine order, or you're caring for an individual who's been advised to self-quarantine. And then kind of a different take is this, or they're caring for a minor child whose school or care provider is unavailable due to COVID-19 precautions. The reason that that one is asterisk is because we're going to talk about it on the next slide with the emergency expanded family medical leave. But it lives in two places. So for now, just know that we're getting there. And the payment on this is for up to 2 weeks, same time period. You calculate their regular rate with up to a 6-month look back, same thing as self-care. Here's the differential on your cost, though. It's a 2/3 rate. So you have somebody who's making $1,200 in a week. You don't have to pay them the $1,200. You would pay them the $800 because it's 2/3. And then again, because they're caring for others, the maximum amount per day is capped at a lower rate. So it's a $200 day maximum for a total of $2,000 across the week. So then we'll look again at that asterisk one and flip forward. Caring for, and I tell you what, while we're flipping to that slide, let me mention something because I've got this question a lot. And I do not have a perfect answer for you because the government has not yet given us one. But lots of counties and states are telling folks shelter in place, stay home, stay safe, isolate in your home, don't go to work. The question has been asked a number of times, does that count as a quote unquote federal, state, or local quarantine or isolation order? We do not have guidance on that yet. On the one hand, everybody's being told to stay at home. On the other hand, that's not really an order to quarantine because you can still go to the grocery store under most of these orders. People can still do reduced, I'm going to go to the veterinarian clinic because my dog's got a problem. If you are ordered quarantine, one of the arguments, if you are ordered to be quarantined, you would not leave your home. So does this apply? Does it not? We don't have an answer yet. We're monitoring that on a routine basis. It matters to you now because we really hope we have an answer by April 1st. If you pay somebody who's under a shelter-in-place order and you point to the statute bullet that says, oh, well, I paid them 2 weeks of pay because they were under a shelter-in-place order, is the taxing authority going to say, gosh, that was so nice of you, but it doesn't qualify as a reason for a tax credit because shelter-in-place doesn't equal quarantine or isolation order? And again, I think that we will get guidance on that before April 1st, but I don't expect to have that in the next day or two. So you probably want to start looking at the end of this week or across the weekend at websites to see if we have an answer to that. But for now, I think you're risking maybe you don't get your tax credit. So now we're on expanded FMLA paid leave. The FMLA paid leave applies to any employee who's been with the company for 30 days or more. The one we just talked about on the split screen applies for every employee. If you happen to hire somebody yesterday, they would be entitled to this paid leave 2 weeks. But in order to get to the FMLA paid leave under this COVID, they have to have worked for you for at least 30 days. That's probably going to be most everybody because I'm not seeing a lot of hiring that has happened in less than the last 30 days. So FMLA has been around forever, and the general concepts are if you have 50 or more employees in a 75-mile radius, you're covered as an employer. If the employee who would like to take the leave has worked for you at least 12 months and performed 1,250 hours worth of service for you in the last 12 months, they are eligible to take it. And then the reasons that you can take it historically are the birth, adoption, or fostering of a child, the employee's own serious health condition, or the serious health condition of another. To the extent you get COVID, your employee gets COVID, or their parent or child gets COVID, I think the FMLA Department of Labor is going to look at that as just use your garden variety FMLA, serious health condition, check. But what this expansion on this act does is now you're going to get a check. So expands the list of the qualifying reasons by one category. To care for a minor child whose school or care provider is unavailable due to the COVID precautions. So if you've got an employee whose child's school has closed and they cannot come into work and they cannot telework, they're allowed to raise their hand and say, I would like to take time off. I need to manage my child at home. They get up to 12 weeks. As I talked about earlier, this is all going to expire by December, so we're not going to worry about this for 2021, at least not yet, unless they change something. The first 2 weeks, maybe it's paid. It may be paid if they say, oh, I want to use that emergency paid sick leave. You know, I'm at home caring for a child, purple stuff on the last slide. I'd like to be paid for these 2 weeks. They would get paid at the 2/3 rate of their regular rate of pay. They don't have to take it. They can save it for later. They may say, well, I'm at home and I'm healthy. I don't want to take my 2 weeks now because that's capped at 2/3 of what I make at $200 a day. If I don't use that money now, if I end up with COVID myself, I could get 2 weeks at $511 a day cap. So they don't have to use it, and you can't force them to use it. It's their choice. They are also allowed to take whatever paid time off they might have through your company if they have such a thing. But again, unless your company's got a policy in place, they have to use it. I wouldn't force them to use it. Some folks may just want to try and hang tight for 2 weeks and see what happens next. Weeks 3 to 12. And again, they're not guaranteed 12 weeks if they don't need it. If all the schools resume 7 weeks into their leave they've asked for, they're expected to come back to work too. But for as long as weeks 3 to 12 as they will go, they are entitled to be paid 2/3 of their regular rate of pay, capped at $200. So if you think of it in categories, COVID leave to care for a child is going to get you $200 a day max. The employer is going to have to pay up to $200 a day max. If it's to care for someone else, we're applying that same math. It'll only go 2 weeks. And if you yourself or your employee are sick, you're going to get a higher cap. So that's the nuts and bolts of it. What does matter, next slide, is you want to make sure you're not giving people a hard time about this. I think Alison has made a fantastic point. Hear your people out. Listen to what they're looking for. If you don't have information and answers, I would add to the list, tell them that. I think it's much better to say, that's a great question. I don't have an answer to that yet. We are in contact with people who are monitoring this situation. We are monitoring developments. These things are changing rapid fire, and right now, I just don't have an answer for you. That's okay. What you don't want to do is have somebody who comes into your office and says, hey, I saw something on a news feed that the Emergency Paid Sick Leave Act is in place and my kid's school is out of service. I want to take paid sick leave. You don't want to say to them, oh, we don't think that's effective until April 1, but you just told us that you're going to take it when it becomes effective. We don't need your services anymore. That's going to get you in trouble. What you'd rather do is say, I don't know that that's effective yet. Let me look into that. Let me find out. It may be that we can't do that until April 1st. Question remains to be answered by the Department of Labor. If you secretly in your back office decided to lay folks off and you intentionally included this person to avoid having to pay them, I think that person is going to file a retaliation claim. It's not written in the statute that it would stand on the language of the statute, but I bet the Department of Labor will take that into consideration. I think you want to be very focused on hearing your people out, sharing information that you can point to something and say, here's where I heard this. I think this is right, but lots of things are changing. And then if somebody takes any of this leave under either the paid sick leave or the emergency family medical leave, and then they file a complaint, don't take any action against them. There is some relief for companies with fewer than 50 employees. Like many things, we don't know exactly what it looks like yet. And the Department of Labor admits on their website that, quote, it will be addressed in more detail in forthcoming regulations. So we're kind of on hold. But the Secretary of Labor, the Department of Labor, has the opportunity to sort of give people a pass on floating the money to their employees if doing so would, and the language from the statute is, jeopardize the viability of the business as a going concern. What regulations do when they come out from the government is it answers questions like, what does jeopardize the viability of my business as a going concern mean exactly? But for now, if you're looking at it and you're thinking, oh my gosh, it's April 3rd, I have all these people whose kids are at home with them because of childcare reasons, There's no way I can float them 2 weeks. I don't have it. I think reach out to your lawyer, reach out to your tax advisor, and walk through what you need to be telling your employee in that circumstance. I think what you don't do is just say, oh, I don't have it, bummer. I think you're going to have a better message than that says, we're really small, we're under 50 employees. It appears that this is something that they recognize. If we don't have the money to float that, we can't be expected to float that. Still looking at this for you, not really sure what it looks like, but thanks for asking me about it. I will get back with you. And then we're going to have to see exactly what the regs say at that point in time. And then, next slide, you don't want to get it wrong, because not only I think you put your tax credit at risk, but you can also get in other trouble. Both the Fair Labor Standards Act, which manages how people are paid in the United States of America, minimum wage, child labor, overtime, things like that, and the Garden Variety Family Medical Leave Act, which provides family medical leave to folks under certain circumstances, those both have some pop as far as penalties. If you're not abiding by them, you get in trouble, and get in trouble usually means you're going to write a check, either to the government or to your employee or to both. So for purposes of the paid sick leave, they're looking at this as this is an FLSA. If you don't do it wrong, it's no different than paying somebody $4 an hour. So don't do it wrong, or we might come after you and say, well, you should have paid him that. And the Fair Labor Standards Act has this nifty liquidated damages that says, we think you should have paid them $5,110 and you didn't. So now all of a sudden you owe $10,220, and we just double it up as a penalty. FMLA is going to do the same thing. They're going to run through whatever would happen bad to you under the FMLA Act will happen bad to you under this Expansion Act. There is a 30-day grace period. So if you didn't get it right, let's just call it for the month of April. You didn't get it right. You tried hard, but you were off a little bit. Maybe there was a document you should have gotten signed and you didn't, but you tried to get people paid. You accidentally paid somebody at a $200 a day cap instead of the $511 a day cap because, you used the wrong trigger. You should get a pass. You should get some grace. You will have to make good on it. So what I expect that's going to look like is a lot of people saying, oh, why are you yelling at me? I didn't know that was the wrong way to do it. I tried really hard. Here's why I did what I did. And then your governmental agency is going to say, well, we see you tried hard. You didn't quite get there. Here's what you should have done. Now go make good on it. We want your employee in the position they would have been had you been perfect the first go round. And folks, there's going to be a lot of imperfection in managing this because it's very new. And again, I don't think we're going to have regulations as long and deep as we'd like to. So everybody's going to be working on the information that they have in front of them. And then my last slide, and we'll jump ahead just a little bit, last section slides, are don't forget their other rights. We've talked about good old-fashioned Family Medical Leave Act a little bit. Here are the tricks to that, who's qualified, what companies are covered, and what you have to do. That didn't go away. So still be mindful of that. You also have to be mindful of the Americans with Disabilities Act. Qualified individuals with a disability are entitled to reasonable accommodations. And then interactive processes, the EEOC's fancy term for don't hear a question and give an answer when somebody asks for an accommodation. This situation is making me so anxious. I can barely breathe and I can't sleep. I think I need to take some time off. That is going to likely be considered a request for an accommodation for a disability, because disabilities include both physical and mental impairments that limit somebody's activities. I'm getting lots of questions about that. I can tell you that the Department of Labor is getting lots of questions about that because they have a section on one of their alerts they issued yesterday that talks all about what do I do if somebody's anxious? What do I do if they come in and they tell me that their depression is overwhelming and they can't work? Don't just say, yeah, that's happening to all of us. I need you here. Or, gosh, if you can't manage that, you need to find a different job. Those answers are going to get you in trouble. So interactive process means you basically say, again, thank you for letting me know that. Let's talk more about what we think we could do to help you out. What is it you think would be best for you? Is it best for you to work from home, even though I could have you in the office? And could you do that without hurting your business? Is it best to give them a week off, just total leave, mental health leave, so to speak? You need to be thoughtful about that. And then the last two, whatever your company's paid time off policy is, now's a good time to take a look at it. If you let people take paid time off for anything, then you should be paying them if they ask you for it for COVID-19. If you typically say you can't take time off without 2 weeks advance approval, I would encourage you to sort of rethink that if you've got the money in your coffers to pay people out. I think companies that are able to and choose to treat their employees as best as possible under the circumstances are likely going to have more loyalty from those folks. They're going to be invested in helping you when you come back. And there are creative things you can do. I've talked to folks that have said, can I reduce everybody's wages by 20%? And I think Alison will talk to some of those things in furlough versus layoff. But, you know, wage and hour concerns, look at what your budget looks like and look at what you can do. And are you better off to lay 20% of your staff off and everybody else marches on whole? Or are you better to input a 20% reduction for everybody and not have to, you know, lay anybody off in the short-term place? But vacation and sick pay, if you have it available, you've got money to back it, and your employees are asking to take it, I'd encourage you to think about letting them take it. Even if not 100%, say, look, we can't pay everybody 100% of what they've got accrued, so we're capping it. We'll pay anybody who needs to take it out of their own personal PTO bank. We'll give you up to half right now. We're going to have to wait till later for some of the others. That's a cash flow issue. And then as Alison mentioned, you know, OSHA, ever our friend of making sure that we have a safe workplace to work. If you have somebody in your shop, in your area, or a customer, passenger, whomever, pilot, who tests positive, OSHA would probably tell you you need to send a notice out to them that says, we want to alert all of you, somebody who was in our building within the last 4 days has alerted us they've tested positive for COVID-19. We will continue to ask that you socially distance. We will continue to disinfect on a frequent basis. If you have questions, feel free to ask us. Short version under the ADA and under HIPAA, the question you're likely to get most, who is it? You can't tell. So your answer to that is, under federal laws, I'm not at liberty to tell you who that person is, but we did want to let you know that it has occurred in our workplace. And if you've got concerns, we can talk to you about that. Here's the last day they were here was whatever date. People ask all the time, well, if you give them stuff like that, here's the person in my back mechanic's office. The last time he was here was on Tuesday, and somebody who he lives with in his home has been tested positive. Okay, everybody now knows that's Mike. That's okay. You just can't walk in and say, hey, everybody, Mike's wife has tested positive. That gets you in trouble. And with that, I'll kick it back over to Alison.
Thanks, Michelle. At this point, I think it's, you know, a good time to talk about, I think we've pretty well covered how to manage your existing workforce and deal with some of the hurdles and the challenges. The next areas that we're going to cover are really what happens when you can't maintain your workforce. Are you looking at furloughs, layoffs, terminations? And, you know, a question that has come up is, with particular with the 135 operators and those that manage aircraft, is what happens when an owner is looking to sell the airplane as a result of the economic downturn, and who's responsible for those employees. And it's basically the person who's responsible is the person who's paying them. So whoever's cutting that paycheck is going to have to make determinations as to whether those pilots need to be terminated, which means that, you know, it's a separation from the employer and that it's not temporary, it's a permanent separation. So you have options available to you of termination, layoff, furlough. So a furlough is something in the middle. There's many different options for furloughing. It's an alternative to laying employees off or terminating them. Furloughs can be a reduction in hours. They could be taking a week or 2 weeks of unpaid time. And how you structure that is really up to the employer and what makes sense. You know, Michelle touched on it. You have to do an evaluation as to, are you better off furloughing employees? Are you better off just laying off a small portion of employees, those are the really tough decisions that you all are making in this environment. If you are looking at furloughing, you want to be careful about making sure that you don't furlough employees in a way that creates a problem for you under the Fair Labor Standards Act. So your exempt salaried employees, those employees, if they work any portion of a week, you have to pay them for the whole week. You have to pay them their salary for that whole week. So reducing hours isn't going to help you there. Instead, you really need to look at, taking a week or 2 weeks of unpaid time. During a period of a furlough, you're going to continue to provide benefits. You're going to continue to provide all the benefits that you offer to that employee, including continuing, their health insurance. During the period of furlough, the employee may be entitled to unemployment. It's really driven by state law. There's plenty of flexibility for ceasing operations, for quarantine, or leaving employment due to risk. So there is some ability for them to recoup their financial losses through unemployment, but it's really going to depend state to state. Where I am in Connecticut, Connecticut is very flexible about these, and they're basically encouraging in email blasts statewide anybody who has a reduction in hours, who can't work because of childcare concerns, any of those reasons, to file a claim for unemployment, and that they may be entitled to it. So they're just encouraging everyone to file a claim, and then they're going to make those determinations. Now, layoffs is a temporary separation from work. You're going to, at that point, it is effectively a termination, except you're going to call it temporary and you're going to call it a layoff. But with a layoff, you will terminate the benefits. You'll put the employees over onto COBRA if they so elect, but you'll have to provide them with that notification. You also have to provide the required separation notice if one is required in your state. Again, that's a question for state law. And then as to whether or not a separation notice is required in order for that employee to claim unemployment, that varies widely from state to state. One thing to touch on is if you are laying off pilots, or terminating pilots, you want to look at a couple of things that I think are going to be huge issues that are going to be litigated and tied up in the courts for many months beyond the shelter-in-place orders, hopefully. Many management companies, many 135 operators do have agreements with their aircraft owners for the owner to provide pilots with severance payments in the event of a termination or a layoff. So that's something that you as 135 operators should be paying attention to and looking at, and go pull those contracts off the shelf and look at whether or not the owner has any obligation to offer those pilots that you're laying off any sort of severance. Another thing I think is going to be an issue is, what about those pilot training contracts, where a 135 operator has a contract with a pilot for the pilot to have training at flight safety, wherever it is, and those are very expensive benefits that the pilot receives, and many times the 135 operator does put in place a contract with that pilot to recoup some portion of those training costs if the employee leaves within a certain amount of time. And I think that those are going to be huge issues that you all are going to be wrestling with. There's no clear answer. It's really going to be a question of what does your contract say with the pilot, and whether or not the contract is ultimately going to be enforceable. I think that in the current environment, it's probably not going to look favorably upon any employer who immediately goes after a pilot on a training contract because, you know, they've been terminated. I usually encourage employers to include provisions that indicate basically that, you know, the training contract doesn't apply, the repayment obligation under the training agreement doesn't apply if the employer terminates the employee. But it's really going to depend upon what your contract says, and you're going to have to look at those. But I would not jump so quickly to go off and start demanding that pilots repay portions owed under a training contract. The other issue I wanted to touch base on is the WARN Act. The WARN Act requires that companies give 60 days notice when they're going to do a mass layoff of, you know, or a furlough where more than 50 employees are impacted. I think that what's going to happen here, and again, it's less than clear, but I think what's going to happen here is that a reasonableness standard is going to be applied. There is an exemption for unforeseen circumstances. I don't think anybody is going to be able to really successfully argue that this was somehow a foreseen circumstance. So I think that the employers are going to get the benefit of having that exemption. I still can't emphasize enough that you should maintain, you know, reasonableness. If you can provide your employees with any notice is better than no notice. So you just want to handle that reasonably and make sure that if you do have to lay off employees, and if you would fall within the WARN Act, that you just do it in a reasonable fashion and give them as much notice as you possibly can. Not entirely separate from the contractual obligations that you may have to your employees. I know we touched on the training. I think it's worth spending a little bit of time talking about force majeure clauses and whether COVID-19 is going to trigger them, as well as, you know, whether or not you might have some other ability to get some relief in these incredibly stressful times. Shannon, can we just skip ahead to the next slide? Great, thank you. So force majeure clause is a provision in contracts. It's present in a lot of contracts, probably a majority of contracts, and it excuses a party from its obligations under the contract when circumstances arise that are beyond that party's control, and generally makes performance inadvisable, commercially impractical, illegal, impossible. And I think that, you know, COVID-19 would fall within a lot of those provisions. Whether or not you're going to be able to exercise the rights to excuse performance under the contract is going to depend upon the specific language of your contract. So what does your contract say with respect to what is a force majeure? Generally, if it only says an act of God, that a court may look at that and say, you know what, that's too broad. If your force majeure clause excuses performances in case of pandemic and specifically says pandemic, then your force majeure clause is probably going to be enforceable. It's going to vary from jurisdiction to jurisdiction, but the language that you have in your contract that you're relying upon for excusing your performance under it, that's going to be critical here. The next thing is, you know, was COVID-19 foreseeable at the time of contract? Generally, I think that you're probably looking at excusing performance of a term under a contract that has that was signed long before anybody could imagine that COVID-19 was going to be a pandemic, that it was going to have the kinds of consequences that we're currently wrestling with. But if you signed your contract last week, then COVID-19 was probably foreseeable at the time you signed your contract, and your performance under the contract may not be excused. So, that's something that needs to be considered. Then the next thing that, a court looking at this is likely to consider is whether or not your non-performance is a result of COVID-19. What's the circumstances? And it's going to be very fact-driven and require, analysis of your language and the facts and circumstances of the time you entered into the contract, as well as those that are preventing your performance. And, a court's going to pull all that together, look at all the evidence that you have demonstrating that you can't perform it, and make a determination as to whether or not your performance should be excused. So I think those are some of the things that we're going to be seeing with respect to force majeure clauses. And it may very well be a case that you might see it in the context of, any types of contracts with your pilots, or, you'll definitely see it within your leases, and trying to navigate those. But those are generally the things that you're going to be looking for. If you're going to, go down the route of saying, hey, I can't honor my contractual obligation because of COVID-19, I would strongly encourage you to reach out to your counsel, provide them with a copy of the contract, provide them with all the details, and let them give you an analysis as to your likelihood of, success if you, ultimately seek to be excused on for reasons of COVID-19. So the other thing that I think is a general concern out there, not necessarily related to employment, but a big concern for aviation employers, is what are your obligations? Now that your business has had a dramatic downturn, you've probably laid off employees, you're looking at laying off employees, furlough, all sorts of things. Do you have to continue to pay rent to your landlord? And this is going to be kind of tricky. If you're an aviation business based at an airport, there's going to be some federal obligations that may come into place. So if you're an aviation business based at an airport that has received federal funds within the last 20 years, or is an airport created as a Surplus Property Act airport, then that airport's federally obligated. The airport is likely, I can't imagine circumstances, and all the guidance that I've seen from FAA to date has seemed to indicate that airports are going to remain open. So if the FAA is keeping airports open, you're there, you have your leasehold, there's nothing precluding you from accessing it, you're going to have an uphill fight to say that, your performance under the lease should be excused because of COVID-19. Having said that, I think that there's lots of opportunity to seek relief from your landlord, offer creative solutions. It's not all about rent abatement. It could be, deferring rent. It could be offering either a percentage of the gross receipts, or increasing the percentage of gross receipts if you are a tenant that is obligated to pay gross receipts to an airport. Those are all things that might be available to you that you should, be communicating with your landlord about. Obviously, seek the advice of your trusted counsel. Reach out. If they're not familiar with your lease, provide them your lease, provide them the facts and circumstances that you're currently faced with, and ask them about, whether or not any of this makes sense, and then ultimately make a decision and communicate with your landlord, offer the landlord these solutions that you can propose whatever you're comfortable with, and enter a dialogue and see if you can figure a way through it and make it work. It's really important to note that if a federally obligated airport is making accommodations for tenants, it really should be making accommodations to all tenants. So if you are a tenant at a federally obligated airport and you know that another tenant across the ramp from you, it has entered into an agreement to either have rent abated for several weeks, months, or to, adjust the rental payment in some meaningful way, then, there are provisions within the landlord's obligations under the federal grant assurances for the landlord to make those same or similar accommodations to all tenants. So that's something that you want to monitor and be careful of, and certainly exercise if you know that another tenant at the airport is receiving some benefits. You want to pay attention to that and raise it with your landlord and ask them for similar relief. The landlord may not give you the exact same relief, but it should be similar in nature. So it's going to be very circumstantial, but I think that there's plenty of opportunity to have those discussions with your landlord and try and make something work. So I think that, while not exactly in line with, a discussion on employment, that's certainly another opportunity for the, an aviation business to try and recover from this, disastrous economic downturn created by COVID-19. And I think,
Perfect.
Were we going to have some questions, Ryan?
Well, yeah, and so that's what we've been compiling everyone's questions that they've been submitting. So in an effort to be just mindful of everybody's time, what we'll do with those questions, we'll get those answered, and we will get those blasted back out via email to everybody who registered for the webinar today. So I really want to thank everybody who joined. I know these are some real challenging times for everyone. So please, a couple things. The podcast has been recorded, so you can go to nata.aero, the website, and find it there, and we can also send it out to you. In addition, if you have any additional questions, please email me directly at ryanw, RYANW, at nata.aero. I want to thank Allison and Michelle for all of your information and time. And like I said, we will get everybody's questions answered. So be looking for that, okay? Thank you for everybody enjoying. Stay safe.
Thank you, Ryan.
Bye-bye.
Thanks, everybody.
Bye-bye.